Good afternoon, everybody. Thank you for joining us for today's online talk, which will be starting soon. For those of you who are here early, thank you so much for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody, and thank you so much for joining us for today's online talk entitled Am I a Tax Resident in Malaysia? My name is Carolyn Ng, and I'm a pupil with Mawengkwai & Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce to you the firm and what we do. Mawengkwai & Associates is a mid-sized law firm that was founded in 1985 by Datuk Mawengkwai. Our able team today comprises of 22 lawyers and a support team of 19. Datuk Mah is today a consultant with the firm, following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWK online talk series. By way of a background, we have actually been organizing monthly lunch talks in our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, as well as in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event that you do require specific legal advice to your matter, please contact us for a complimentary legal consultation. The details of that will be given at the end of this talk. We have with us one speaker for today, Ms. Christine Toh. She'll be speaking on tax residency in Malaysia. We will then conclude with a Q&A session at the end. Allow me to introduce to you Christine Toh. She is a partner at Mawengkwai & Associates. She is also a member of the Association of Chartered Certified Accountants, a certified adjudicator, and empaneled with the Asian International Arbitration Center. Her areas of practice include construction, adjudication, arbitration and litigation, taxation, family law, as well as contractual disputes. I will now pass the floor over to our speaker for the day, Ms. Christine.
Thanks, Carolyn. Let me share my screen. Thanks for the kind introduction, Carolyn. So this is the overall top points that I'm going to talk about today. A very brief introduction, overview of the Income Tax Act, and also the understanding tax residency in Malaysia for both individual and corporate, income tax rates for residents and non-residents for both individual and corporate. Just a very brief overview of the Income Tax Act. The Income Tax Act is the main source governing the income tax system in Malaysia. It was introduced back in the British colonization period to legitimize collection of taxes from individual and corporation. And in 2001, we have moved to what we call now the self-assessment system. Taxpayers are now answerable to the tax authority in case of a tax audit. And in gist, all income accrued in, derived from, or remitted to Malaysia is liable to tax. We will explore this definition further in due course. These are the common type of tax that we encounter. For individual is our personal income tax. For company is corporate tax, and sometimes we are liable to withholding tax. And there are other indirect taxes such as sales and service tax, which replace our previous GST, and real property gain tax. Now we will proceed with the tax residency in Malaysia. Am I a tax resident? The notion of tax resident in Malaysia for individual depends on the physical presence in Malaysia. And this is defined in Section 7 of the, sorry, it's not Insolvency Act, it's the Income Tax Act. So there's 4 situations defined in Section 7. Number 1, Section 7 sub 1A is where the stay in Malaysia in that particular tax year is more than 182 days. Section B, sub B, deals with a situation where you stay in Malaysia for that particular year for less than 182 days, but somehow it was linked to the year immediately preceding or following the tax year. Right after this, I will show you some examples so that it will be easier to understand what all Section 7 means, the 4 scenarios in Section 7. And the third situation in Section 7 is where you stay in Malaysia for more than 90 days or more in the current year, and 90 days in the 3 out of the 4 past 4 years. And that lastly, Section 7(1)(d) deals with where you reside in Malaysia in the following year and has been resided in Malaysia in the 3 preceding year on being taxed. Okay, so the wording by itself sounds rather complicated. Now I will show you an example. It will make it easier. So let's take an example of Mary, who is from UK. And this is the details of her journey between UK and Malaysia. In this particular year of assessment 2021, she was traveling between Malaysia and UK for 90 days, for 70 days. At the beginning of the year, she was in Malaysia, whereas sometimes in the middle, she was in UK, and then she came back to Malaysia, and then she went back to UK again. So the question is Mary a tax resident in Malaysia for the year of assessment 2021? This is rather straightforward. All you need is that 182 days. It doesn't need to be it can be a collective period. So if you take 70 plus 100 plus that 12 days, it exceeds the 182 days, then she will be a tax resident for the year of assessment 2021 under Section 7 sub 1 sub A of the Income Tax Act. Now we move on to the second provision, which is Section 7(1)(b). Section 7(1)(b) dealt with actually what we call a temporary absence. So it's a form of relaxation in this 182 days rules. So what happened is that during this temporary absence, you were not in Malaysia because of these 3 reasons. So the absence, the first thing is that the absence is connected with the individual service in Malaysia. Example, you attended a conference, you went for a seminar, or you study abroad. The second reason is that you were absent in Malaysia due to ill health involving the individual or a family member of his immediate family. And lastly, it was the absence was due to social visit, not exceeding 14 days in the aggregate. So if you may note, for the first and second allowance, so in terms of the definition of temporary absence, there is no time limit. Whereas for the third, which is the social visit, there is a cap of 14 days in aggregate. Now, so let's take this Mary's example again. So what happened is that you were in Malaysia in 2021 for a short period of time of less than a month. That is year of assessment 2021. Then thereafter, from 23rd of December until 7th of January, you were temporarily absent in Malaysia. And assuming that this temporary absence was due to the 3 reasons that I have explained earlier. Then after that, in 2022, beginning of 2022, you came back to Malaysia and you stay here for more than 182 years. So now the question is whether Mary is a tax resident in Malaysia for the year of assessment 2021, taking into consideration she was just here for a short period of time. So what happened pursuant to Section 7(1)(b) is that the number of days in 2021, although it's short, but it is linked to 2022. And of course, like I've said, the temporary absence was due to the 3 reasons, the proviso in Section 7(1)(b). And of course, then there is at least 182 days, consecutive days in 2022, which is the long period that I have showed just now. With that, Mary will be a tax resident for year of assessment 2021, pursuant to Section 7, Sub 1, Sub B. Now, let's move on to the third scenario. So this is what happened. 2017, Mary was here for 234 days. 2018, 151, that's short of the 182 days already. But this 2018 is for the purposes of this example, I want to show you how Section 7(1)(c) work. So that is actually the question for actually 2021. Whether Mary is a tax resident in Malaysia for the year 2021 in view of Section 7(1)(c). So 2017, 234 days. 2018, 151 days. 2019, less than 90 days, which is just 31 days. And 2020, again, 153 days, exceeding the 90 days. And 2021, less than the 182 days, but it exceeds, less than 182 days. So now the question is, just based on this set of scenario, for year 2021, whether Mary is a tax resident. If you look at the provision in Section 7(1)(c), it says that 3 out of the 4 preceding years, Mary is in Malaysia for more than 90 days. And that is satisfied by reason of her number of stays in 2017, 18, and 2020. So that is that I've just explained. And hence, Mary will be a tax resident, although she stayed in Malaysia only for 120 days in 2021. This is, again, fairly straightforward for Section 1D, if we put it in the example. So what happened is that, let's say 2017, the whole year she was in Malaysia, 2018 she was in Malaysia, 2019 she's in Malaysia, 2020 she's not in Malaysia at all. And then 2021, she came back to Malaysia. So what Section 7(1)(d) do is that it will make Mary a tax resident in 2020, despite her not being in Malaysia at all in 2020, because it satisfied the 2 conditions under Section 7(1)(d). Then, insofar as individual is concerned, insofar as a company is concerned, in deciding the residence status of a company, the key features that the court will look at is actually the place of management and control of the business. It was defined to determine the residence status of a company under the Income Tax Act. It is defined in Section 8. So number 1 is where a Hindu joint family resident for a year of assessment, a manager or kata is resident for the basis year, a company or a body of person carrying on a business for the basis of a year of assessment if at any time during the basis year the management and control of the business is exercised in Malaysia, a company or a body of person in Malaysia for the basis year if at any time during the basis year the management control of its affairs are exercised in Malaysia by its director and other controlling authorities. What amounts to management and control? The IRB issued a public ruling 9/2021 2019, dated 6th of December 2019. Basically, management and control, as I've said, it is the main factor to be considered. So it is where the controlling authority which determine the policies to be followed by the company, and it also considered to be exercised, i.e. management and control, is considered to be exercised where the director meet to conduct business affairs regardless of the location of incorporation. I have some example here. This is the example given in the public ruling. So what happened is that Jet Limited, a company incorporated in Hong Kong, has businesses in Hong Kong, Singapore, and Malaysia. All the businesses of the company are managed and controlled by the head office in Hong Kong, except for a brief period in 2018, let's say, where the management and control was exercised. So this is where, because there's one board of directors meeting which was held in Malaysia, where important policy decisions were made on a particular date. And this date fall in the basis year for the year of assessment 2018. So what happened if you only have one board meeting in the whole year in Malaysia? What happened is that this will still amount to the management and control being exercised in Malaysia on this particular date where the board was held. And although there's only one board meeting held on that particular year, Jet Limited is considered a resident in Malaysia as the management and control was exercised in Malaysia in the basis year of assessment 2018, despite it being only just one board meeting. We talk so much about being residents and non-residents. So what are the differences? Let's talk about individual for now. In terms of personal income tax, you are liable to pay tax for any income that you earn in Malaysia or receive in Malaysia on a scale rate, of course. Income tax is payable whether you are tax resident or you're non-tax resident. So this is the scale rate. For anything above 2 million, you will be subject to a 30% tax flat rate. I'm sure we are quite well versed with these haunting numbers. So in terms of the advantage of being a tax resident in Malaysia, as a tax resident, you're entitled for a scale rate of what I have showed you here. Is calculated based on your chargeable income. Whereas for non-resident, if you receive income for business, trade, or professions, you are not entitled for the scale rate, but instead you are liable to pay tax on a flat rate basis. For year of assessment 2016 to 2019, the flat rate was 28, whereas for 2020 and 2021, the flat rate is now 30. And of course, tax residents are entitled to personal relief, such as wife relief, child relief. And as a tax resident, you are also entitled for rebate if your chargeable income does not exceed 35,000. And other advantages of being a tax resident in Malaysia is that you are exempted from certain payments on the tax exempted from payments on royalty for literacy of artistic work, income from cultural performance approved by the Minister of Culture, Arts and Tourism. Whereas for tax rate for non-residents, as I've said, is a flat rate. So business, trade or profession, income that you receive from business, trade or profession, employment, dividend, rent, you're subject to a flat rate of now is 30. Whereas for other income that you receive, such as your royalty, your public entertainment, interest, whatnot, it is also subject to a flat rate of 10 or 15. Depends on the type of income that you receive. In terms of applying for tax resident, this is more applicable for people like expatriates, those in Malaysia. Apply for a certificate of resident in Malaysia. You can apply through online portal e-residence, or at any IRB branch in Malaysia. Of course, you need to bring together with you important records of CTC, your passport, list of entry and exit of Malaysia, because that is important to determine your tax residency. Copy of departure, flight tickets, confirmation by your employer on the period of employment, and other supporting document which you think is relevant. There are certain exemptions for the non-residents. So income for a non-resident individual is tax exempted if derived from an employment exercised by him in Malaysia for a period less than 60 days in a year, a continuous period which overlaps 2 successive years of assessment but not exceeding 60 days. I will show some examples so that this definition will be easier to understand. So say Phillips is from Philippines. The detail of his journey between Philippines and Malaysia are as follows. He was in Malaysia for 11 days and he earned income in Malaysia. Then he went back to Philippines and then he was in Malaysia again for 40 days and then he went back to Philippines. In that case, the total number of days in Malaysia is less than 60 days. Then Phillips can apply for tax. The income earned for year of assessment 2021 is tax exempted as he is not physically present in Malaysia for a period exceeding 60 days in a year of assessment, which is 2021. There are other exemptions as well. If you are employed in Malaysia for less than 60 years, which I've explained, employed on board a Malaysian ship, or you're aged 55 years and were just receiving pension from Malaysian employment, and if you were just receiving interest from banks or receiving tax-exempt dividends. In terms of residents and non-residents for individuals, for corporates, the tax rate are slightly different in the sense that for SME, where your payout capital is less than 2.5 million, you are again on a scale. For the 600,000, for the first 600 chargeable income, your tax rate is only your tax rate is 17%, and anything above 600,000 will be at a rate of 24%. This is actually there are more differences in terms of the tax treatment if you're a resident company or a non-resident company. I have just extracted some of them. The entire list can be found at the IRB website. There is an extensive public ruling on this, the difference between a resident company and a non-resident company. This is just a small part where I want to introduce that as a payer, i.e. you pay someone who is not a non-resident in Malaysia, but the payment made is actually for services rendered or technical advice or rental or other payment made to the non-resident payee. Then you are actually, as a payer, you are the one who is paying. You are actually required, duty bound to withhold tax. So, and because the payee is a non-resident, it will be hard for the IRB to go after them. So as a payer, you are duty bound to withhold this tax and pay it to the IRB on behalf of the payee, and hence it's called a withholding tax. Then now, as very quickly on the responsibility of a taxpayer. As I've said just now, we have moved into the self-assessment since 2001. So what you need to do is that you need to declare, calculate your own tax, submit tax return, and then pay tax. Foreign national working in Malaysia are liable to tax under the Malaysian domestic law in respect to employment income derived in Malaysia. As long as your income derived, accrued in Malaysia, you are liable to pay tax. The issue is whether you are a non-resident or a resident, because different tax rates and other tax treatment will apply for non-resident and resident. Whereas for a company, registration of a company tax filed by the individual who manage and operate the company. Usually it's quite common that we will engage a tax agent to do this. Registration can be done online through e-Daftar or physical at any IRB branch. So these are really procedural in nature, what you need to do in order to register. These are the type of offenses that you may be liable if you fail to carry out your obligation as a taxpayer. Well, again, lastly, I will say that it is important for you to understand your requirement and your liability, your responsibility as a taxpayer. Okay, that's about it for my presentation. And now we will move on to Q&A. But for now, I will pass the screen back to Carolyn.
Thank you so much, Christine, for all your insights. So we have a few questions here. I think we can all see them through the Q&A box. So the first one for today, I am a freelancer. Do I need to pay taxes?
Okay, so freelance in the sense that this is not very clear, but I'm assuming that you derive income in Malaysia and the income was accrued in Malaysia, and hence the short answer is yes. But it depends on, again, then the next thing to determine is whether you are a tax resident or you are a non-tax resident, because that will impact on the tax rate that's payable.
Thank you, Christine. Next question. I am an expatriate in Malaysia and my head office is in Hong Kong. They paid my salary. Do I have to pay tax in Malaysia?
Again, this is it boils down to Section 3. It doesn't really matter whether you are expatriate or otherwise. The tax is payable for income that you accrued in or derived from or received in Malaysia, even though it's from outside Malaysia. So the first thing to determine is actually the source of income. Okay, let's say you are expatriate and you get paid because of the services you render in Malaysia. Then the income will actually have a source of Malaysia source. It will be a Malaysia source, and hence it's taxable. Then, as I've said, the next thing is to determine whether you are residents or you are non-residents. That is based on the number of days, Section 7 that I've shared with the audience today. And let's say if the source is not a Malaysian source, it's a foreign source. Say, for example, rental income that you receive from a rental of an overseas property, then it is a foreign source. Then it is exempted. You are not taxable for that income. So it depends very much on the source of income rather than where it was paid or where you are.
Okay, our next question. I have a company in Malaysia and there are transactions, but the management team is in Singapore. Do I have to pay tax?
The management team, okay, that is, then now we go back to Section 8. Section 8 actually says that the residency of a company depends on the management and the control of the company. So like the example that I have given earlier, even though all businesses are in, their businesses was in, I think, Hong Kong, Singapore, and Malaysia. But just because you have one board meeting in Malaysia for a particular year of assessment, that is enough to render the management and control of the company for that particular year was exercised in Malaysia. So it really depends. If you tell me that you are in there's nothing in Malaysia at all, there's no management and control, then no, the answer is no, even though you have a company in Malaysia and there are transactions.
Our next one. Can IRB go after the director of the company if the company failed to pay taxes?
This is actually a very interesting question. I got asked quite a number of times based on this. And before I go into, I might want to share a case law, this year's case law with the audience. But before that, the short answer is it's possible. There is a provision under the Income Tax Act, which is the Section 75, capital A. This is where a director can be held jointly and severally liable for tax payable by the company. And what jointly and severally means is that the IRB, the government, can either sue the company by itself to recover the tax, or sue the director and the company together, or the IRB can choose to sue only the director, not the company, to recover those debts. So what amount to a director under Section 75A is not that there is a legal definition to it. It was provided under Section 75A. It's not our normal understanding as to what a director means under the Companies Act. Number one, the first criteria is that there is you have to occupy a position of the director. Okay, so you must be someone who is concerned in the management of the company business. So that is one criteria. Another criteria to fall under a definition of a director under Section 75A to be liable for the company tax personally is where you as a director own or in control. Yeah, the key here is in control of not less than 20% of the shares capital of the company. So you have the 20%, and you are a director who are concerned with the management of the company, then yes, if the company fail to pay tax, that the liability, you can be personally liable and be sued. So now bring me to this Court of Appeal decision. This one is what we call, this case is called the Government of Malaysia against Mahavira. So what happened is that the government here it has started in High Court. The government commenced an action against the company and the director. And that was for outstanding paid tax assessment from, I think, 2000, many years ago, 2001, 2, 3, and 4. I think it's these 4 years. Okay. So what happened was that the director was only appointed in 2003, let's say. The assessment was for the 2001, 2, 3, and 4, but the director was only appointed towards the end of 2003. So now the issue before the High Court is that the tax assessment raised was in the region of 3 million-ish. So in before the High Court, the company didn't turn up. So it was a judgment in default was obtained against the company. So, and then the government was going fighting with the director. So now the issue before the court, one of the issues before the court was whether the director was only appointed in 2003. And the tax assessment was raised way after that. It was raised in, I think, 10 years later, 2014. So the questions before the court is that whether the director who was appointed in 2003 are liable for the tax assessment for 2001, 2, 3, and 4. Those 2004, yes lah. That's what the High Court held actually. The director is liable for the tax assessment in 2004 after her appointment. So what happened to 2001, 2002, and 2003? 2003 because it was she was appointed like in December. So the High Court held that the director is not liable. The director is not liable for tax assessment for the year before she was appointed. And the government of Malaysia is not happy with the decision, so it was appealed to the Court of Appeal. And the Court of Appeal disallowed dismissed the appeal, and the High Court decision actually stayed. So what the Court of Appeal actually said was that it would be unjust, it would be very unreasonable to hold the director liable for things that she even before she was appointed. The argument put forward by the IRB was that the debt only accrued, it was only payable when I give this assessment, which is in like 10 years down the road. So when I gave this test assessment in 2014, she was already a director, and hence she should be liable. But the Court of Appeal was not with the government, and hence the appeal was dismissed. I think the matter is before the federal court now. We do not have I don't think it has been decided yet. So we will have to wait and see if there is any changes to the law, whether the director can be held liable for tax assessment year, which is prior to your appointment as a director. So that is insofar as the director's liability is concerned. That is a very quite a hot topic.
Thanks so much, Christine. That was a really interesting case you brought up.
Yeah.
I'm pretty sure all of us can go and check it out after this. Our next question is, I just received a tax assessment recently, which I find it totally unreasonable. How can I challenge it?
Actually, in fact, I received another call this morning actually on the raising of a tax assessment, which is totally unreasonable. So in short, you have two options. Okay, the first option is to appeal to the commissioner, but bear in mind that you have this 30 days period to do it. So there's a 30 days time limit. You can apply for EOT, but the ground to get EOT is not easy lah. You're not going to get an easy one. So then after on the first option is that then the commission will actually decide, and if let's say you're not happy with the decision, you may still appeal to the High Court, but chances are, because the High Court is of the opinion that this is a specialized field, so they are not likely to disturb the findings of the commission, and you can only appeal on a question of law. So the ground is not very wide lah. Yeah. Another option that I have stated just now, the other option is that you actually apply for what we call a judicial review on the tax assessment. But judicial review is actually a two-stage process. First, you need to ask for leave. You need to ask for leave. In the leave stage, what the court would think that is you must present an arguable case. You must present an arguable case. You don't have to show that you sure win. There was a sure that this assessment is totally going to bound to fail. But you need to argue. You need to show that it's an arguable case. So and then once you get the leave, i.e., the permission for judicial review, then you will enter the second stage, which is where the merits of the judicial review will be assessed. So that's your two options if you're not happy with a tax assessment.
Thanks, Christine. Our next question. What are some useful and accurate resources for self-education on individual taxes?
Actually, online, the IRB issue a lot of public rulings. You can just search on the IRB website, and most of them are actually in English. So it's very easily accessible. I think we are still, okay, as much as I want to answer all these questions, but we are running out of time. What I can do is that you all can drop me an email. Drop me an email, then leave me your number, or if you prefer, I can just try to answer you by email, or if not, you can contact our team, and we can have a consultation, the 30 minutes free consultation.
Thank you so much, Christine. I'm so sorry we are running a bit short on time. Like our speaker said, her email is in the chat box now. You can contact her for anything. Before we end today, thank you so much, Christine, for the talk today. Before we conclude, I just have a few announcements to make. First of all, please do join us for our upcoming talks. The details of those are on the screen now. The first one is on the 15th of September, the do's and don'ts of retrenchment. This will be conducted by our employment team. And on the 22nd of September, we have another talk on resolving disputes in administration of estates. Secondly, please do fill out our feedback form and tell us what you thought of our talk. The link of the form will be posted in the chat. Thirdly, do follow or like our social media accounts as shown on the screen. We have all these different platforms. We do post our talks on YouTube, so you can rewatch back any of our previous talks as well. And fourth, if you would like to speak with our lawyers, we offer a complimentary 30-minute video consultation over the telephone or video conference. Please do fill out the form on our website. The link is also posted in the chat box. To all of our guests, thank you so much for joining us today. We hope that you have found today's session informative and useful. Thank you, everyone, and we will see you at our next talk.
Thank you, everyone. Have a great evening. Stay safe.